When is a defendant's conduct negligent? Is a defendant negligent simply because the defendant fails to take every precaution against every foreseeable risk? We explore those questions in Pitre versus Employers' Liability Assurance Corporation. The City of Thibodaux Volunteer Fire Department hosted an annual fundraiser known as the Thibodaux Fireman's Fair. The fair contained amusement rides, food, and games. One particular game, the baseball concession stand, challenged players to knock over items with a baseball to win a prize. Players threw baseballs from behind a counter approximately 20 feet away from the targets. Canvas flaps surrounded the back of the booth. Although the area between the counter and the targets was roped off, the area around the players remained open to the public. No attempt was made to separate players from other fair attendees. The firefighters who operated the concession remained near the ropes on the inside of the counter. 9.5-year-old Anthony Pitre and his family attended the fair one evening. Anthony got too close to David LeBoeuf as LeBoeuf was winding up to throw an overhand pitch at the baseball concession. LeBoeuf accidentally struck Anthony in the head as he pulled his arm behind him. Anthony died from his injuries. Anthony's parents sued Employers' Liability Assurance Corporation, the fair's insurer, for Anthony's death. The Pitres alleged that the fair was negligent because it failed to warn fairgoers of the risks inherent in the baseball concession and because it failed to take steps to separate players from other attendees. Fair expert George Everett Henderson testified on Employers' behalf. Henderson explained that baseball concession's only substantial safety concern is the risk of ricocheting balls. Henderson testified that he routinely operated baseball concession stands without barriers between the players and the general public. As with the fair involved here, Henderson also placed his concession workers near the ropes inside the counter. Henderson had visited hundreds of similar concessions and had never seen the area around the players cordoned off or otherwise restricted. The trial court entered judgment for the Pitres. Employers appealed to the Louisiana Court of Appeal.